The hearing is in the matter of CFI 001-2021 before Justice Lord Angus Glennie and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Davidson & Co. Lead counsel is Stephen Doherty. The defendant is represented by Pinson Masons LLP. Lead counsel is Sophia Hurst.
Thank you. Mr. Doherty, I think it's your application.
Yes, thank you, my lord. As you'll have already picked up, this is the claimant's application for immediate judgment. The claimant says that really this is a very simple case. And in very short outline by way of introduction, it relates to arranging and advisory services that were provided by the claimant to the defendant in late 2019 and early 2020. And those services related to the defendant's investment in Egyptian Treasury bills, or T-bills for short. Those T-bill investments were arranged on the defendant's instructions between December 2019 and February 2020, with subscription amounts totaling approximately 237 million Egyptian pounds. And in return for those services, what was
that figure?
That was 237 million Egyptian pounds.
Yep.
And in return,
what's that in US dollars? Roughly.
Yes. So the dollar amount. Bear with me. I will get it from documents so I'm as accurate as possible. It may well be that I'll have to work that out. What I have is the total Egyptian pounds value, which was then converted through an equation to the subscription fee, which is the 1.5%. So I have the dollar value for the 1.5%. I'm not sure I can do that calculation in the top of my head.
Okay, don't worry.
Certainly. But I can find that out for you, and I can perhaps deal with it in reply. But as I've perhaps alluded to there, in return for those services, it was agreed that the defendant would pay the claimant 1.5% of the T-bill subscription amounts, and in that case, the 1.5% amounts to a little over $190,000 US. And the defendant's been invoiced for fees in connection with those services, but to date has refused to make payment. Yeah. And a number of different reasons have been given for that since these proceedings were raised. In effect, the defendant makes 3 points. First is that although the claimant did provide services in relation to what we've been referring to, as you might have noted in the pleadings, as the first transaction, it says it subsequently agreed to waive those fees. The second broad point made is that the claimant didn't provide any services at all in relation to the second transaction. And third, it said that the defendant has a counterclaim for an alleged breach of contract by the claimant in respect of the services it provided. Just pausing there very briefly for one moment, it's perhaps worth pointing out at least that although the parties have been referring to the first and second transactions in these proceedings, to some extent that is a bit of a misnomer. Both transactions were effected as part of the same overarching investment in T-bills, and it might be slightly more accurate to view that as being in effect two tranches of the same overall investment, albeit ones that were made at different times. That aside, for reasons which I'll come to in more detail, we say that the defendant's arguments fail to pass even a basic sense check and have no real prospects of success. The defendant...
If I can interrupt you, you've summarized three arguments. I thought there was another argument, which is that the defendants say that any commission was due only on a leveraged investment arranged by you or through you, and that even the first transaction didn't qualify for that.
Yes, that is. I suppose I was dealing with them in broad heads. When I come to dealing with our more specific submissions on that, I'll deal with each of the points that fall under those broad heads, including that submission in relation to the leveraged investment. I can give you the short answer to that now, which I think I perhaps alluded to in describing these investments as not necessarily being separate transactions, but part of the same overarching transaction. We, in effect, say that that argument isn't engaged in this case because for both sets of investments or both tranches of investments, leverage was arranged. But I'll come on to that in due course.
Right.
But you're quite right in identifying that is one limb of what the defendant is saying.
Mm-hmm. Right.
What we say, I suppose by way of summary, is that the defendant plainly engaged the claimant to provide certain services which it duly performed, and in accordance with it acted on the defendant's instructions. And we say that the way that the defence is framed is largely based on a misapprehension of the services which the claimant was actually being instructed to provide. And we say in order to determine this application, your lordship doesn't need to look too far beyond the terms of the contract that was entered into between the parties and what are the undisputed facts of this case. We say it's a simple debt claim which is perfectly well suited to immediate judgment. The defendant, as one might expect, seeks to rely on the existence of various factual disputes and suggests that this is a claim that therefore needs to go to trial. But we will invite your lordship in these submissions to treat that particular submission with a degree of scepticism. And your lordship may have noted, for example, and we say by no coincidence, that the quantum of the defendant's counterclaim, without much explanation, is pitched as being almost exactly the same amount.
I've seen that point, but
Yes.
it's good prejudice, but it doesn't really take one very far.
Yes, of course. I think it's more by way of background and how one ought to view the sincerity with which this counterclaim is being pursued. But in any event, we say that's a question for another day. Insofar as there are any issues to proceed to trial which relate to the counterclaim, that isn't something which would prevent the court from seeking to address the narrow issues which are being addressed in this application, nor is it sufficient justification for keeping the claimant out of pocket. And your lordship will have seen that we rely on no set-off provisions to that effect.
Yeah.
So that's in effect a brief overview of where these submissions are going to go. In taking your lordship to those in detail, I propose to tackle that in three ways. The first is to go to the contractual documents themselves, which explain what services the claimant provided the defendant with. The second is to go through the relevant background, including the relevant agreed background, and the reasons that we say the defence has no real prospects of success in respect of both transactions or both tranches. And finally, I'll address your lordship briefly on the relevance of those no set-off provisions in the context of an application like this.
Yep.
Perhaps just slightly before turning to those substantive submissions, your lordship will have noticed I've set out the relevant test for immediate judgment at paragraphs 6 to 8 of my skeleton. You'll be familiar with those. I think the principles are agreed by my learned friend as well as having been set out by Justice Giles and GFH Capital. The only specific part of that that I would draw your lordship's attention to briefly are how the court should approach questions of fact. And I'm looking at paragraph 3 of my skeleton argument on that, and it's bullet point 4 from the English judgment being referred to, which says that the court does not need to take everything that a party says in a witness statement at face value without analysis, and that where the court's also assisted by documentary evidence, particularly contemporaneous documentary evidence, is entitled to determine that there could be no real substance in a factual assertion where it's contradicted by those documents.
Yeah.
So in other words, there's a degree of analysis that can go into this without it treading into being an exploration of facts that would otherwise be for trial. And that's all I have to say about the legal test. what I now propose to do is take Your Honour to the contract itself, which you can find in the Exhibits tabs, which is at C. I don't know if Your Lordship is working off the...
But I'm working off a mixture of things, but I've got the contract.
Thank you. So it starts at C1. Over the page at C2, we can see that it's dated 19th of November 2019. And if we then skip ahead to page C41, if you're on the C41, so that's actually in it's tab 2 of Exhibit C, but it's the supplementary mandate particulars.
Yeah, it's C42 for me.
Yes, that's correct.
Yeah. Okay.
And there we find the section 5 page for this client agreement, and we can see at 5.1 what the mandate is. So it's arranging credit and advising on credit, and it's a non-discretionary portfolio mandate. 5.2 of assets up to 16 million, investment guidelines, investing in Egyptian treasury bills and arranging leverage on them, and then fee arrangements, 1.5% fees in the notional value.
Yeah.
And if Your Lordship then turns to the, it's in a separate tab.
That there's a number of questions I want to ask you about that, but I'm happy to wait till you've gone to other clauses first. But I would like some help on precisely what your obligations were under that mandate.
Yes, well,
words,
perhaps...
It's very well saying investing in Egyptian treasury bills, but what was your role meant to be that you were being paid for?
Yes, perhaps the easiest way to do that is to go through the remaining terms of the contract, which explain the scope of those services in a little more detail, followed by the background, which will explain exactly what did happen and exactly why those fees arise. So on that, if Your Lordship goes to page C24.
I can just pick up in advance. I'm happy to do that, but I want some help in due course on particularly 5.3. I'd like some help on when 5.4, well, 5.3 and 5.4 in the revised mandate, when they came into being, and also what is meant by arranging, in the expression arranging leverage. But take those in the course of your submission.
Yes, bear with me. I'll just take a brief note of that. If I can ask Your Lordship, with that in mind, to go to C24.
Yep.
What you'll find is the terms of business. So this is section 9 of the client agreement. And skipping forward from there, the first page I'll refer to as C27. Where hopefully we get the beginnings of the answer to the question you've just asked. So clause 7, services provided by us.
Yes.
And then we said the services offered by MBE may include one or more of the following on the terms set out in this client agreement. So 1, little Roman 1, providing you with advice and recommendations on financial products, credit facilities, and investments. So there we have the advising portion of it. 7A2, acting as an intermediary between you and any other third-party financial institution, including within the MBE group. This would include accepting instructions and orders from you in respect of an investment and arranging the execution of such instructions or orders by passing on to that financial institution for execution. So there we have a further description of the arranging aspect of those services after the advice has been given. Arranging
there presumably means making arrangements for them to happen. In other words, it's not trying to arrange, it's arranging.
Yes, I mean, it's not obviously prescriptively defined. It can include forwarding on instructions, but in effect, it's here's a transaction we are advising you to carry out. Here is an intermediary financial institution which will execute it for you. Here are the terms we've arranged with them, and then the execution would take place through the third-party institution.
Does it involve putting in place arrangements by which for example, with the leveraging, under which the leveraging will happen? Or is it simply putting in place arrangements under leveraging could happen if everyone else agrees?
Well, I think that the latter element obviously has to form part of it, because the fee only crystallizes upon the event happening. So the entitlement is 1.5% of any subscription fee. So if the investment doesn't happen in the manner arranged, then the fee would never arise in the first place. And in fact, what I'll come on to in a moment is explaining what the parameters of that are by reference to the contract of what these services are not.
Okay.
And then finally on, I suppose, what these services are at 7A5, we have provision of research and other information and materials related to financial products or investments. And then if we go again on the same page to clause 7C1, what we also find is an explanation of what this agreement isn't. So at clause 7C1, under this client agreement, we will not execute transactions or otherwise act as a principal or agent on your behalf in relation to the execution of any transactions. At 7C2, we will not accept deposits or provide credit. And in 7C3, we will not keep investments in safe custody on your behalf.
Yeah.
So there we have a further definition of the parameters. We have that in a little more detail again at clause 8, which relates to advising and arranging services specifically. So clause 8A also explains that we're providing you with advisory or arranging services only, and we are not providing you with discretionary portfolio management services. The following terms will apply to you. So they're obviously applicable in this case because this is a non-discretionary mandate.
Yeah.
And at Little Roman 2, we may provide you with advice from time to time, but we're under no obligation to provide proactive advice or monitor any investments in your portfolio with another financial institution or with MB Group, or to review that advice previously provided to you. Yeah. We agree to advise you in a particular investment, and please note it may be subject to legal and regulatory restrictions. So bringing those threads together, what the claimant is being engaged to do is to provide advice and recommendations in relation to a proposed T-bill investment. It is to arrange those investments by acting with an intermediary third-party financial institution. This is not discretionary portfolio management, which is going to involve proactive execution of orders. It's also clear from these terms that the claimant is not going to be involved in any way with the execution of transactions, either as principal or agent, nor is it the entity which is going to provide a line of credit, nor is it the entity that's going to be a custodian of the assets. And we say that's important in light of some of the observations made by the defendant in the way it puts its defense. I'll come on to that in more detail, but in essence, part of what seems to be suggested is that because the second transaction in particular was executed by Arab African International Bank, AAIB, who also provided the line of credit, that it took fees for that and the claimant wasn't entitled to any fees. But we say that that's a fundamental misunderstanding of the services that the claimant has been instructed to provide. And the point here is that, and as we'll see in a little more detail when I come to the background, the claimant did give advice on those T-bill investments and how it would be structured. The claimant utilized its professional contacts and relationships to arrange the execution of those investments, but also the provision of a line of credit through a third-party financial institution with whom it had a relationship, so that's AAIB, and that forms the scope of what arranging and advising services are. It performed those. It did so on express instructions, and it's clearly entitled to its professional fees for providing those services. As I say, I'll come on to the background elements of that and the facts in a little more detail.
Yeah.
Before I do so, there were a couple of other provisions of the client agreement I'd hope to refer to whilst we're there.
Mm-hmm.
So the first is at C26. At the bottom right-hand side of the page, we've got clause 6.3a, which is, unless expressly provided elsewhere in the client agreement, instructions from you will be acknowledged by us acting on them, unless we advise you that we believe such action may not be practicable or might cause any party to breach any law, rule, or regulation. So, under the terms of the client agreement, the claimant is required, as a matter of contract, to act on client instructions. And there are only a couple of get-outs from that, really. It's if it's not practicable or if it would breach the law, rules, or regulations. The next provision is at page C36.
Yeah.
Which is clause 21, setting out some payment terms. The ones I'm referring to are at A, first of all, we will charge you fees, charges and other amounts for the services in accordance with the fees specified in section 5.4, so that's the 1.5%, or in a separate fees letter agree with you, reasonable notice, vary the fees chargeable or payable, and then at C, unless otherwise agreed, any such fees will be calculated and charged in arrears on a monthly basis. Your Lordship will note that there's nothing in those payment terms which suggests that that is in any way affected by what the investor subsequently decides to do with respect to their investments. So we're not talking about some prorated approach whereby if the investment is made on the advice and arrangement services provided, that it could subsequently be liquidated and you'd only be entitled to a percentage of the fees on a pro rata basis. There's simply nothing to that effect. And then the final point on the payment terms is clause 21E, which is the no set off provision, which says that any fees, costs, or disbursements payable hereunder shall be free of any rights of set off, counterclaim, or withholding, and shall be topped up in the event of any taxation, duty, levy, and charge, etc.
Yeah. Mm-hmm.
So that's the contract. Unless you have any specific questions about that at the moment, I propose to move on to the services that were in fact provided, and by reference to the documents. So the first document I would refer your Lordship to is at C101. Where hopefully you should find the beginning of a November 2019 presentation given in relation to this Egypt carry trade.
Hold on a second. Yep.
No, I'm not going to go through all of this in any detail, but you can see by a fairly brief overview what it contains. So, for example, if one looks at pages C103, there's information on what the investment opportunity is, 104, the investment rationale, 106, we get some further details on the trade itself, and together with some of the data on yields that were available at 107 and 108.
So this is advice that your clients are giving pursuant to the agreement, is that right?
Correct.
Right.
And it's part of a series of advice. So there's this presentation, but it's also undisputed that this is accompanied by a number of meetings which take place from October but into November 2019. And this particular presentation relates to an unleveraged transaction structure, but we can see some of the information that's being provided to the defendant, which is relevant to his understanding of what these services were going to be. So at C109, we are told that the claimant would be responsible for arranging, but not the execution of the investment. And we can see that under the section counterparty.
So where do I see that?
So counterparty, it says MBE DIFC to arrange or manage the investment. And at this time, although this changed, the National Bank of Egypt was to provide execution and custody services. But the point is that MBE, the DIFC entity, is not providing execution or custody services. And we can see that as well because...
But surely there may be no issue on this. I understand that MBE are not to provide execution and custody. They're there to arrange that the National Bank of Egypt do that. And that means they, for example, it would be an obligation on them to ensure that the National Bank of Egypt, wouldn't it?
So this is part of this initial presentation, which, as we'll come on to see, isn't how it was agreed to carry forward. The point was that, yes, we have MBE, the claimant, providing the arranging services, which will then be presented to, in this case, it is National Bank of Egypt, but the point is it can be any third-party financial institution who will actually carry out the execution.
I understand that. I just want to make sure that we're on the as to whether or not there's an issue between us as to what arrange means. As I understand that, if it had gone ahead on this basis, claimants would have agreed to arrange that a situation where the National Bank of Egypt provided execution and custody, and the claimant's obligation would be to ensure that the National Bank of Egypt did that. It wouldn't be enough simply to say, oh, well, we'll introduce you to the National Bank of Egypt, and it's up to them whether they do it or not. We've arranged it. In other words, arranging can carry with it some obligation of ensuring that the third party does this.
I think that perhaps our definitions of arranging are slightly different to the extent that what can be provided is a service whereby effectively the commercial terms are set up by the arranging party. So that here is a third party institution with whom we have an arrangement. Here is the investment that has been proposed. Here is the deal that we have arranged for you to have offered with that party. And now all that needs to happen is this needs to be executed. There are a number of different ways that can be done. It can be done through the arranging party. I mean, this is, of course, just a question of formalities and signing the documents. But it's not invariably the case that an arranging party will, say, forward all of the documents for signature. That can take place between the executing party and the investor directly. The arranging services are effectively arranging the deal itself.
Right. Okay, let's see whether it matters later.
Yes, I would hope that when we go through the facts, it should be clear what the services that were provided up to the point of the investments was. And just finally, on this particular page, we can see obviously MBE DIFC Limited's scope of authorizations by the DFSA is set out there. So arranging deals and investments, financial products, arranging credit, advising on credit, and so on. Mm-hmm. And if we then go over to 110, we find at this stage some explanation of what the subscription cost is going to be. I point this out because a point seems to be taken about this idea of there being a notional value, and that notional value has to involve both a leveraged and an unleveraged component. On the facts, we say that this doesn't really matter, but it's worth noting here that the heading of this slide is key information for the unleveraged structure. And we can see that the subscription cost is still described as being 1.5% of notional value.
Yeah.
The point of notional value is that it captures both. So if you've got an unleveraged investment, it's of the unleveraged investment. If you've got a leveraged investment, it's of both the amount that the investor is putting in plus the amount that the bank or financial institution is putting up by way of credit. And what we also have here is some explanation of what became part of the initial transaction structure, which is the attempt to streamline the investment for tax purposes, which is there's a 20% withholding tax if one goes through this investment in their personal capacity. But if you can manage to arrange it through a UAE company, that would attract a 10% rate of tax. If we then skip forward slightly to page C121,
yeah,
we have there a subsequent document. So this is the 27th of November 2019, which sets out a number of options. So it includes the unleveraged component that we've seen in the presentation, but then we've also got worked examples of potential returns from a leveraged investment of 1 times and 1.5 times.
Right. Can I just ask you, in relation to, this is 27th November 2019, when did the mandate get revised to include leveraged transactions?
Yes, my lord. Perhaps I can try my instructing solicitors listening and take instructions at the revised mandate particulars document is not itself dated. It seems that at the very least it's being put in place. If we can see, that's the next document I'm going to anyway, but page C44.
Right.
It seems to tie in with when, again, this unhelpfully undated document, but it's the execution process for the investment that's eventually proceeded with. But we can see there that 2% is scored out and replaced by 1.5%, and we've got the client signature on that. So one assumes that it's after this advice is given and after the advice on the particular transaction structure is also given.
Mr. Doherty, I'm sorry to interrupt, but just if it's helpful, I think at A7, paragraph 3.6 of the defence, it's pleaded that this document was signed on the 27th of November 2019, which was at a meeting after the client account was opened. And I think that has been admitted in the reply. So I'm sure Mr. Doherty will correct me if I'm wrong, but I think the date is the 27th of November, if that assists.
Thank you very much.
Yes, well, it would certainly seem to fit with the document that we've just looked at, which was the structure for the unleveraged and the leveraged investments.
Thank you.
So if your lordship still has page C44 open, you'll have already gathered from the pleadings and the witness statements, but the original transaction structure was that the investment was to be made through a third party, Global Investments. And we can see reference to aspects of that structure here. So Global held an account arranged by the claimant with AAIB, and Global also had access to a credit facility that had been negotiated and arranged with AAIB by the claimant. And the proposed structure here is that the defendant was to transfer his money to Global's AAIB account, which would then be used to purchase T-bills. Which would then in turn be leveraged using the credit facility that had been arranged with the AAIB. And so the benefit of that structure was, of course, that it would attract a lower level of tax than if it had been made by the defendant in his personal capacity. Mm-hmm. And we can see there, it's obviously in the fourth bullet point from the bottom that for providing those services, the claimant is going to be entitled to its 1.5% subscription fee. It's also undisputed that
for leveraged transactions. Yeah.
Yes. Well, the as you have seen, the mandate particulars say 1.5% of notional value, which explains that notional value is comprised of leveraged plus unleveraged. But I don't think that there's any particular magic in that on the facts of this particular case.
Right.
Another aspect of the arrangement through Global was that in order for it to access the credit facility that had been negotiated with AAIB, so that's a $60 million facility, it would first have to raise $40 million in investment. So the defendant's access to that facility is contingent on the $40 million first being raised. Again, drawing some of the threads together from the documents we've looked at, what we say is that the defendant knew, based on what's set out in these documents and in the client's agreement, that the claimant's role in all of this was to give him advice and to arrange access for him to the credit and to the investment through an intermediary bank, and it's expressly stated here as being through AAIB, and that the transaction on this first structure would be conducted through Global in order to secure that tax advantage. With those points in mind, Your Lordship, I think it might be worth looking at the defence in order to discern some of the undisputed facts up to this point. So that starts at A6. And I'm looking at para 3.1 first of all.
Hold on. Yeah.
So we have recognition the defendant met with the claimant to discuss investment and to begin the process of opening an account. He attended a number of meetings with other members of staff involved as well. So there we've got the defendant accepting that he's attended those meetings at which advice has been given. At para 3.2 and 3.3, we get an indication of the sort of advice that was given, which included in relation to investments on both an unleveraged and a leveraged basis.
Right.
At 3.4, there's no dispute that advice is provided on the potential tax advantages of investing through an Emirati company. And forward to A.
Slow down a bit.
Of course.
Yeah.
And forward briefly to page A9 at paragraph 6.
Yeah.
This relates to the defendant's understanding that to execute, leverage was going to be raised through global investments. The global was to raise the 40 million from investors and to borrow 60 million, so that's the 1.5 times leverage.
Yeah.
Once it had done so. It's also suggested in that paragraph that the defendant didn't know at the time that the identity of this party was to be global. But as your lordship's already seen, I've taken you to the document which spells that out. It refers to both global and the fact that the financial intermediary would be AAIB.
What's the significance of whether they knew or didn't know?
I'm not entirely sure. It's more a point of clarification of something that's been denied, but on the clear facts and the contemporaneous documents, it's pretty clear that global was specifically mentioned. But that's really more by way of an aside than anything. Again, I don't think that anything in particular falls on that point.
Right.
So it's common ground that once this transaction structure has been negotiated, that there's a period of time that elapses in which Global is trying to raise the investment that it needs to unlock access to the AAIB facility. And that provides us to the background for how the first transaction takes place. So in those circumstances where a period of time had elapsed, the defendant was advised that he could seek to make his initial investment utilizing his own funds on an unleveraged basis, and then to arrange the leverage component of that investment later, effectively in order to take advantage of the then available yields and to get his investment up and running. And we said,
where do I find that?
Yes. So first of all, at page C46,
yeah.
So this is the 6-month T-bill. So this is the unleveraged investment that's made in December 19. We have the express instruction.
Sorry, I didn't catch what you said. Did you say it's a leveraged investment or an unleveraged?
This is an unleveraged 6-month T-bill investment.
Right.
So this is an instruction to proceed with making that investment.
Yeah.
So with reference to the above subject, please proceed with the 6-month T-bills. And we, of course, say under the terms of the client agreement, the claimant is required to follow those instructions. If we then scroll to C48, we have an email confirming the purchase of those T-bills. So the value at that stage is the unleveraged portion, which is 33 million. That's Egyptian pounds. And if your lordship goes forward again to page C124,
yeah.
We find an email. So this is setting out a number of queries in respect of the investment. So this is the 10th of December 2019. But for present purposes, all we need to refer to is paragraph 5. Kindly update us regarding the date the leverage will be done. So the client knows at this stage that this is an unleveraged investment and an instruction to purchase unleveraged T-bills, and that the leverage component is going to be arranged later. And that's, of course, a consequence of the fact that Global have not yet unlocked access to the AAIB credit facility.
Yeah.
And then if you go to the page just before that, it's C123. We have 10th of December 2019 document setting out the carry trade calculation for 6-month T-bills, unleveraged. And we can also see a note right at the bottom of that page explaining that the subscription fee is applied to the principal amount.
So this is a document sent to the defendant.
Yes.
Yeah.
Now, what then happens in the chronology, and let me just see if I can dig out the page reference for you, is that an invoice is sent at that stage for the unleveraged portion of the investment, and that's issued in December. I'll come back to that because I've got the document reference as I work through the submissions. But the point here, which is why I think that there's not any particular significance in whether one has to even construe its section 5.4 as having to include a leveraged and unleveraged component, is because although we have an invoice for the unleveraged portion of this investment, what happens is that the leveraged portion of it is completed at a later date. So by the time we get to February, the 1.5 times leverage on this investment is arranged, and the invoice is updated to reflect that. And that's part of the part and parcel of what's called the second transaction, but it's the second tranche, which is the investments made in the defendant's personal capacity. Mm-hmm. And we can see where that transaction comes from in a number of places. So, for example, if you go to page C61, we have an email exchange, hopefully you should find, from the 26th of January 2020. And we can see, with reference to the above subject and the T-bills purchased on the 8th of December, so that's what we've just looked at, we can see that at this point in time, and this is when the meeting is arranged with AIIB, which I'm going to come back to, but for present purposes, if we look at bullet point, it's bullet point 4, first of all. We see if the leverage issue for those T-bills is not resolved yet, then we shall proceed with selling the T-bills as soon as possible and transferring the money to our personal account at AIIB in order to obtain the leverage directly. So what that's saying is Global haven't raised their 40 million yet. If that's not resolved, what we'll do is we'll transfer the 6 month T-bills I purchased into my personal capacity, and we'll arrange some leverage with AIIB in my personal capacity.
Right.
And it's based on those instructions that we can see at C66. This is an email chain in relation to the instruction to transfer those T-bills. So as discussed last week, we expect to receive the term sheet from AIIB anytime soon, upon which we will proceed as agreed. We will also be liquidating the original position and transferring to your personal account at AIIB at the soonest.
So this leaving out Global for this proposed transaction?
Yeah, so we have the original investment which was made through Global. Yeah. Because of the delays in arranging the leverage, what is instructed is let's transfer the sums currently held under Global to a personal account which was set up at AIIB, and from then AIIB are going to execute a trade which builds in the leveraged 1.5 times portion of that investment, but that's all in the personal capacity and therefore not attracting the tax advantage that had been mooted previously.
So would it be right to say, so I'm just trying to make sure I follow, that what is proposed here, because Global have not raised the full amount of the proposed leverage, the defendant is going to take it back into his own personal name and make arrangements himself with AIIB?
No. What happens here is that the defendant receives advice as to his options, and again, I'll come on to this in the context of the second transaction as well, which is effectively you can wait until Global arrange to have Global obtain the 40 million in investment they need to unlock their facility, or we will arrange for you to make an investment in your personal capacity, so you won't get the tax advantage, but we will arrange for you to have access personally to a credit facility with our contacts at AAIB, and we will arrange in setting up your personal account there, arranging the transaction, which will then be executed by AAIB. So it's not, we have nothing left to do here, you're on your own. It's an instruction to set this up in my personal capacity. I, the defendant, am willing to do this, even though I won't get the tax advantage, and you, claimant MBE, sort it out. That's the scope of the mandate in this scenario.
Right, but in terms of the mandate, and just looking at what's happened so far, there's been a purchase of unleveraged, so an unleveraged purchase of Egyptian T-bills, yeah?
Yes.
The proposed leverage through Global hasn't materialized, yeah?
Correct.
A proposal is put forward by the claimant that a way around this is to transfer transfer everything to the personal account of the defendant at AAIB, who will provide the appropriate credit.
Partly, it's not the personal account of the defendant at AAIB. The defendant doesn't have an account at AAIB at this point in time. The reason that the deal is structured in this.
I was simply reading from the email. Your personal account at AAIB.
Yes, so the personal account at AAIB was set up on the date of that meeting, so the 22nd of January meeting.
Yeah.
Again, I'll come on to all of this in detail, but what effectively happens is the claimant has the defendant into their offices for a meeting. They say, we've got our contacts at AAIB who are willing to offer you a credit line on the same terms as we've previously arranged with the Global investment. The defendant is then taken to AAIB's offices by the claimant, and on the same day opens up his accounts, and the arrangements are made for the leveraged investment in his personal capacity.
Okay.
So that's what I mean by it's not the case that there's some pre-existing relationship with AAIB, and the defendant's just gone off and arranged these things himself and asked the claimant to transfer the portion they dealt with. The whole basis for the deal would not have existed without the claimant's input.
Okay.
But just very quickly finalising the position with the work and the continued services that the claimant is providing in respect of the first transaction. We've also got the email we've just looked at discussing the request for term sheets from AAIB, and also that they would be taking steps to liquidate the original position. So that's the unleveraged position held through Global, and transferring that to the personal account that had then been set up at AAIB as the vehicle for making the investments in his personal capacity. Then at C68, we have an email from the claimant to the defendant attaching a T-bill buy order. So that's to give effect to the transfer of the amounts invested through Global to the personal account with AAIB. At C73.
So it's the same T-bills or a new lot of T-bills?
So my understanding is this is a transfer of the T-bills. If we go to C73, we have the signed application for purchase, and it's the same value of T-bills to the 33 million, and the same maturity date.
So I'm getting confused then, because I thought there had been a purchase of T-bills back in December.
Yes, there has. So it's the same amount, 33 million.
On leverage purchase. Now, I don't understand how the same T-bills can be the subject of a new purchase from the this document is what from. Well, can you explain to me?
Sorry, Lordship, I think I missed that.
Well, if the defendant had already purchased the unleveraged T-bills on the 8th of December, which is C46 or thereabouts, how can it be the same T-bills that he's purchased again or giving an order to purchase in January 2020?
Sorry, yes. So my understanding is, so the first set of T-bills, the December purchase, is arranged through the Dubai entity, so Global. So yeah. It's held in Global's name. The arrangement for this sort of second transaction was to have, as I understand it, that position liquidated by Global, and the investment would then be made in Mr. Omran's personal capacity.
You've gone dead. Hello?
My lord, I can still hear you, so I think it's a connection problem on Mr. Doherty's side.
Right. Mr. Doherty, are you there?
Sorry, I am here now. I've just been kicked out. I wasn't ducking a question.
Well, you hadn't. You were explaining, I think, how this document at C73 is for the process, I think, whereby Global were dropping out of it, but Global, the T-bills having been purchased in Global's name were, I suppose, is a form of transferring them to the defendant's name. Is that right?
Yes. So the investment in effect becomes one which is held in Mr. Omran's personal capacity, and it's from there that we get the leverage portion of that being arranged again in his personal capacity by AAIB. And then this is, again, just to complete the documentary record on this, page C76.
Yeah.
We see that AAIB then received the signed instructions from Mr. Omran, which we've looked at, and then at C132, we have a summary of the transaction itself.
Give me a second. (132).
Yes, I hope I've got that right. Bear with me.
Right. I see.
So then we see
the purchase, and then 18th February is what?
That's the leverage component. So that's 1.5 times the investment, giving us a total investment in respect of the first transaction of 75,453,396 Egyptian pounds.
Yeah, I see.
And so I hope that brings together why it is that we say this isn't just a question of whether you can siphon off the unleveraged component. The point is that this was a leveraged investment. It is one that was arranged by the claimant and the total value of the leveraged investment is the 75 million for the first transaction. It's just that there's the first tranche of T-bills which are bought in December, and then the leverage component of it is completed in February, but that's the total amount.
Right. Okay.
And then this should hopefully just assist your lordship with putting together where the figures in the particulars of claim come from. So first of all, at C93,
yeah,
we have a breakdown of the calculations for it's both sets of transactions, but the first transaction is a bullet point 2, and we can see the annual fee calculation in Egyptian pounds, and we work out 1.5% of that. That's then divided in 2 because these are 6-month T-bills.
yeah,
Then we have that converted at an FX rate into dollars, which gives us 36,090.59. Pausing there, your lordship will note that a discount has been worked into this calculation. No doubt you'll have picked up that point.
I've seen the point about that, yeah.
And that same position is reflected in the invoice, which for your note is at C91. I don't know how much detail you want me to go through on that. In effect, the claimant's position is it offered a discount of the fees equivalent to 1 month T-bill yield as a goodwill gesture in light of its broader dealings with the claimant. We say,
Yeah.
and I think the defendant accepts that offer was never accepted, and so doesn't apply.
Yep.
So coming on to the claimant submissions with respect to the first transaction, we say that our claim for payment is fairly simple. The claimant provided the defendant with detailed advice on T-bill investments. It gave presentations. It attended a number of meetings with the defendant. It advised on a tax-efficient structure, which was initially proposed and agreed. But when there were delays in one component of that, which is global raising the money it needed to unlock the facility, which the claimant would have had the benefit of, the claimant advised the defendant that he could make an unleveraged investment to take advantage of the yield rates that were then available and to then arrange leverage on that subsequently. We have an express instruction from the defendant to proceed with making that investment. The claimant then arranges for that investment to be executed. So it's by AAIB, who's the banking intermediary who carries out the execution of this and holds the funds. But it was the claimant who's providing the arranging and advisory services. It's access to this credit facility in the first place was entirely derived from the claimant's relationships with AAIB and the negotiations it had with MBE and with the negotiations it had entered into with AAIB. That same credit facility on the same terms was subsequently arranged for the defendant to have access to make leveraged investments on this transaction, albeit that this time it was in his personal capacity. He took advantage of that trade. He instructed that trade. The investments were transferred from Global to his personal bank account, which was set up so that trade could be executed. And we say that the claimant is entitled to its 1.5% of the subscription amounts based on the work that it's carried out. And the defendant really makes a number of points to say that this is not an issue which is suitable for immediate judgment. And one of the central aspects of its defense is it says that the claimant waived its right to payment in order to make good the defendant's losses. So that's reducing or extinguishing almost to a cent the amount that was payable. We say that that argument clearly doesn't work. First of all, it's a very simple point, but an important one. The defendant hasn't provided any evidence to support the existence of an agreement to waive the claimant's professional fees. This is the second point, which is connected to that. We would say that the documentary evidence clearly points towards the fact that the claimant has in fact maintained its entitlement to those fees throughout. And for that matter, the defendant has acknowledged its entitlement to pay. We know that because the claimant sent an invoice for those fees, not once, but twice. First of all, for the unleveraged amount on the 11th of December 2019. That's at C58 for your lordship's note. And again, we get an invoice for the same transaction on the 20th of February 2020, which for your note is at C91. Clearly, that would be a course of conduct on the claimant's part which would be entirely inconsistent with it having earlier agreed to waive its fees.
Mm-hmm.
We also have contemporaneous email evidence to support the claimant's case. So that's at C59, which I'd ask your lordship to look at.
Yeah.
It's an email chain from the 25th of December. We can see that the email, first of all, at the bottom of the page, also on the 25th of December, says, "Trust this email finds you well." Reference to below email, please note that we still did not receive the funds. Kindly provide us the SWIFT copy so we can track payment. And the response to that is with reference to your earlier email. Please note that we shall settle the invoice after the leverage process is completed. Furthermore, it was agreed earlier that the payments will be done quarterly. Therefore, please review the invoice accordingly. Also note that, as per our last meeting with Mr. Hussein, the delay in completion of the leverage process shall be settled by MBE. A couple of points to make about that email chain. The first is the fact that the defendant was suggesting that there were delays in completion that would be settled by the claimant. We say does little more than provide some context to why a discount was subsequently offered as a goodwill gesture. It's obviously not an agreement to waive the claimant's fees. If there had been an agreement, first of all, Mr. Omran says in his own words that he's talking about a previous agreement that had been reached. Well, if that sort of agreement had been reached, we wouldn't have had the earlier email on the 25th of December chasing up payment.
Yeah.
We also say that this email is, of course, further evidence that the defendant was aware that he provided instructions to carry out the unleveraged portion of the investment. But third, what we have in the first sentence is an express acknowledgement by the defendant that he was going to be liable to settle the invoice. He's just saying, I'm going to do it after the leverage process has been completed. So there can be no doubt that the defendant owes money in respect of this transaction. And built into that is a clear understanding that moving forward, the claimant was going to be involved in the process of arranging leverage on that investment.
Yeah.
So in those circumstances, we say that there's no real prospect of the defendant being able to establish a waiver of fees, which completely contradicts the documentary evidence and his own contemporaneous statements. And I've touched on it already, Your Lordship. The claimant is seeking payment of the full fee owing to it and not the discounted amount. And the reason for that is Paris 16.3 for your note. And you already have my point about my invitation to treat with a degree of skepticism the value of the counterclaim. But moving on to the other lines of defence, the second point raised by the defendant is that the first transaction was not entered into in compliance with the mandate, or that it represented a breach of the claimant's best execution policy. And again, we say that that's a submission that doesn't really work. First of all, we say it misunderstands the scope of the claimant's mandate, which is to provide advisory and arranging services. So as we've already seen from the client agreement, it was never intended or understood that the claimant would be directly providing a line of credit or executing this investment. In that context, it's slightly unclear, and we say the defendant hasn't really explained at all how it is that the claimant's best execution policy is said to have been engaged. It's not providing execution services, nor is it providing a discretionary portfolio mandate. And so that doesn't really go anywhere. The second point we'd raise is that it's also within the scope of the claimant's mandate that it is expressly required to act on client instructions. And if it didn't, the claimant would very much be risking a separate claim for breach of contract and breach of mandate. To that extent, the defendant provided its express instructions to arrange, first of all, the unleveraged portion. We've seen the email to that extent, but also to arrange the leveraged portion of the investment, which is why we see the emails in relation to obtaining term sheets. It's why we see the emails in relation to the transfer of the investment from being under Global to being in Mr. Omran's personal capacity. The third point we'd raise is that one of the arguments the defendant is seeking to raise is that the mandate required that 1.5% would only be payable where the claimant had arranged both the unleveraged and the leveraged portion of the investment. And that's based on the argument that section 5.4 of the mandate particulars refers to fees being 1.5% of notional value. With respect, we say that that's not a good argument. Let's say, hypothetically, under such an arrangement, if a client were to decide that they no longer wanted to leverage their investments at all and provided an express instruction to arrange the purchase of a number of unleveraged T-bills, what the defendant's position suggests is that the claimant would be entitled to no fees for that at all. And we say that's obviously wrong. That's a misinterpretation of what notional value means in that context. And we've also seen that from the presentation that was given to Mr. Omran back in November, which was an unleveraged investment and used that term notional value. All it means is that there can be two components, an unleveraged component and a leveraged component, but where there is an instruction to proceed on the basis of an unleveraged investment, the notional amount is just the unleveraged amount. There's no sort of particular magic in the fact that it captures both and therefore has to have both components. It's just saying it can be one or other. In any event, that argument it's a bit of a straw man, because on the facts of this case, it doesn't really arise, because what we say is that the leveraged portion of the investment was arranged anyway and crystallizes in February 2020 when the leveraged portion of the investment is executed by AAIB. And the final point that seems to be raised, the final point on this sub-issue is that even if the defendant were able to say that there had been a breach of mandate or a breach of best execution policy, and that resulted in some loss, there's no provision in the client agreement which says that it's entitled to withhold its fees on that basis. And I remind your lordship of the no set-off clause, which we looked at earlier, and I'll come back to in a little while. So even if that case is made out, it's not an entitlement to refuse payment now. The proper course is to pay now and sue later. The final point raised by the defendant on this transaction is to say that he subsequently liquidated his 6-month T-bill investment prior to maturity. and so the claimant couldn't be entitled to the full fee. And again, we said that doesn't have any prospects of success. First of all, we've seen the payment terms under the client agreement, and they provide that you pay in arrears effectively the month after the investment is made. That is in no way conditioned on what the investor decides to do with his investment, whether it's to hold on or whether it's to liquidate early. There certainly wasn't any provision which said that were an investment to be liquidated early, that some pro rata fee would attach to it. Such a provision, we say, would actually make no sense in the context of this sort of services because, of course, the advisory and arranging services that are being provided will always be provided up to the point the transaction is executed. And as I've already taken your lordship to clause 8C2, there was no ongoing obligation to monitor investments. So it's not like the investment is made and that there's some ongoing service in relation to that investment. By the time it's executed, the services have already been performed in full. And so it obviously makes sense that payment would be made in full regardless. So drawing that together, we say that each of the arguments raised by the defendant in respect of that transaction have no real prospects of success. And so we ask for immediate judgment to be entered on the full amount attaching to the first transaction, which is $36,090.59.
So give that figure again.
36,090, so 36090 and 59 cents.
And that's for what?
That's for the first transaction, which is an investment in 6-month bills with a total value of 75,453,396 Egyptian pounds. Yeah. And the calculation is at C93 for your note.
Yeah.
So that's the first transaction. Moving on to the second transaction, or the second tranche of the transaction, the relevant background, as we know, and the parties agree, is that Global had, of course, been required to raise the 40 million to unlock the facility. That process was taking longer than expected, and so the claimant advised the defendant that his options were either wait or to obtain access to a credit facility in his personal capacity. And it's common ground that the defendant opted for the latter of those two options. As I say, the leverage over the Global investment is something that had already been arranged by the claimant through AAIB. And given the size of the investments that we're talking about here, so notional value of $100 million, but 40 million is the principal sum that's being put in, that was offered by AAIB on pretty competitive terms. And it's those same terms that were then made available to the defendant in his personal capacity. And again, I think it's common ground that in order for him to access that facility, he was going to have to put up a minimum investment of his own of $5 million. Now, in order to proceed with that transaction, the claimant arranged a meeting between the defendant, the claimant, and AAIB on the 22nd of January 2020. And we have reference to that meeting at C60, which is a document we've already looked at, albeit on a slightly different point.
Mm-hmm.
So we can see in the top line there, it's please note that as per our discussion on 22nd of January 20, the following was agreed. AAIB has stated during the meeting that leverage shall not be approved unless there is a minimum amount of $5 million USD, which can only be achieved by selling the T-bills purchased earlier and transferring them to our personal account. So that's why there's a degree of crossover between the first and second transactions. And we've already looked at some of the documents and the steps taken by the claimant to give effect to that portion of it. You'll have also seen the reference to the 5 million minimum investment. One of the things that the defendant suggests, and again, it might be one of those points that nothing particularly turns on, is that it hadn't been informed of that minimum level investment by the claimant. Just a couple of points on that. Very briefly, at this bullet point, which is the defendant's own email in point 3, there's no indication of him having been unaware there. It's just simply saying, during the meeting, this was explained. But if you also look towards the bottom portion of this document, we have the previous email from the 6th of January, which makes it clear that a certain amount was going to have to be received. So what's being discussed here is a 25 million investment, so that I can secure your allocation of the leverage. So what we say by that email chain is that, first of all, it's pretty clear that the claimant has been telling the defendant what is going to be required in order for him to make his investment through AAIB in his personal capacity, and that the claimant has arranged the meeting for the defendant in order to make that happen. But beyond that, and in fact beyond the documentary record itself, one doesn't actually need to delve too far into the evidence to determine this aspect of the claimant's case. And we say that it's already there in the defendant's own pleadings, which I'd ask your lordship to go back to. It's starting at A6. But the first paragraph I'm going to refer to is paragraph 11.
Mm-hmm.
So I'm referring to the final sentence in this paragraph. Mr. Tantawi explained that the US 40 million from investors was required to unlock the 60 million facility, which NBE had negotiated and agreed with another bank, AAIB. So the defendant accepts that the claimant had previously negotiated and arranged a credit facility with AAIB.
Mm-hmm.
At paragraph 12, first sentence, first of all, Mr. Tantawi advised that Mr. Omran could either wait for Global to raise the investment and so be able to complete the transaction with AAIB, approach another firm to arrange a credit facility, or transfer the funds into his own name and secure the facility from AAIB. So the defendant accepts that the claimant is giving him advice that one of his options is to transfer the funds to his own name, so in his personal capacity, and to secure the facility from AAIB, which is the facility we've just looked at in paragraph 11, one that has been negotiated and arranged by the claimant. Perhaps more importantly, also at paragraph 12, this is the final sentence it's the fourth line from the bottom. It says, Mr. Omran instructed NBE to transfer the funds into his personal capacity and arrange the leverage with AAIB.
Mm-hmm.
So again, the defendant is accepting that he provided those instructions to carry out this investment in his personal capacity, and importantly, to arrange the leverage with AAIB. Again, that's the leverage that had previously been negotiated as part of the global investment. Skipping to the next page, I'm looking at paragraph 15.1. Which refers to the 22nd of January meeting. At the meeting between Mr. Tantawi and Mr. Omran, 22nd of January, and in order to mitigate Mr. Omran's losses, which Mr. Tantawi had agreed MBE would compensate. Mr. Tantawi also offered to introduce Mr. Omran to AAIB in order to pursue the investment through AAIB. Mr. Omran agreed, and Mr. Tantawi accompanied him to AAIB's offices to introduce him. So there, we have the defendant accepting that, first of all, he has no prior banking relationship with AAIB. He's physically being brought there by the claimant. And that, of course, is in the context of having already admitted that he instructed NBE to transfer the funds to his personal capacity and to arrange the leverage with AAIB. And of course, we then know that the claimant does accompany him to a meeting at those offices. The next provision of the defence is paragraph 15.3. Mr. Omran signed the documentation to open an account with AAIB on the 22nd of January. Under the terms and investment mandate of that account, AAIB were to purchase and leverage T-bills and was entitled to charge a fee for its own services. Mr. Omran's account was opened on the 23rd of January, and he instructed NBE to coordinate with AAIB to procure that the T-bills and Global's account were transferred to his own account. So on the very same day that the claimant introduces the defendant for the first time to AAIB, takes him to AAIB's offices in the context of their instructions to arrange the credit facility in his personal capacity with AAIB. The defendant goes there, he's given forms, he opens an account, and he is offered the facility to purchase and leverage T-bills, and that the claimant would further coordinate the transfer from Global to his personal account in order to secure leverage on those funds as well.
Yeah.
And then at paragraph 15.4, we have confirmation of when the credit facility is then signed on the 28th of January 2020, for which he pays a 0.5% leverage fee. Now, none of what Mr. Omran says in his defence is, I went to AAIB of my own volition, I negotiated a credit facility on X terms, and I did all of this on my own. That's simply not what's happening here, even on the agreed facts of this case. What happens is that the defendant instructs the claimant to arrange the investment in his personal capacity. The claimant takes him to their offices. The documents opening his account are signed in the presence of the claimant on the same day. The terms of the facility are the terms that had previously been offered on the global investment. And it's, we say, a complete fallacy to suggest that this is something which is operating independently of the advisory and arranging services which are provided by the claimant. And so it's in that context that your lordship has to view the defendant's contention. And in respect of the second transaction, effectively, its only case is to say that the claimant didn't provide any services at all. But when one delves into it, the only real rationale that seems to be offered to explain that is that it's AAIB that actually offers the credit facility and that actually then goes on and purchases the T-bills. But that aspect of the defence doesn't have prospects of success. First of all, it's on a fundamental misunderstanding of what the services actually being provided by the claimant were, which is advisory and arranging services. And the defendant seems to be operating under the misapprehension that just because the investments were made in his personal account, that they were not advised on and arranged by the claimant. But that's plainly at odds with what the client agreement says, which makes it clear that the claimant wasn't going to be providing credit itself. It wasn't going to be executing transactions. It was going to arrange investments through third-party intermediaries and financial institutions. And that is precisely what's happened in this case. The second point is that it's clear from the undisputed facts that I've just taken your lordship to, that the claimant did provide those advisory and arranging services. So we've got all of the advice provided on the T-bill investments all the way back to October 2019, including in a number of alternative structures, which wasn't just through Global, but was also in relation to investing in one's personal capacity. That makes no difference as to whether advisory services have been carried out. The defendant has, of course, accepted that he had no prior relationship with AAIB and was introduced by the claimant. It's not in dispute that the claimant had previously arranged access to a credit facility with AAIB, as we've seen in the execution process document for the global investment. When that didn't take place, what we know is that the claimant arranged for the defendant, without any prior connections or contacts, to attend a meeting with the AAIB at their offices, open an account on the same day, and be granted access to a facility on the same terms as he had previously. And the claimant then arranged for the transfer of the investments then held in Global to his personal account. So this is in respect to the first transaction when leverage is then arranged on them. So we say on any analysis that plainly falls within the scope of the claimant's mandate under the client agreement, and it's entitled to be paid for that. But your lordship doesn't just need to take my submissions on that. We also have the contemporaneous statements, or at the very least implicit contemporaneous statements made by the defendant himself. So, for example, if we look at page 81 of bundle.
Just while you're being taken to that, I'm conscious that we're over halfway through our allotted time, and I wondered if I could have an indication from the friend as to how much longer he's going to be.
Fair question.
Not too long. I'm more or less at the end of the submissions on the transaction, and I can deal with the no set-off point pretty briefly.
Well, that's already set out in writing. I don't think there's any need to go through that already.
Certainly. In that case, I was referring your lordship to page C81, and I'll be brief.
C81.
Yes.
Yeah.
So this is an email from the 30th of January 2020, and it's the bottom part of this. Dear Engineer Mohamed, kindly approve that any email correspondence regarding your T-bill transactions, which we arranged on your behalf with Arab African International Bank, is shared with MBE for our records. Yeah. And if you scroll up to 79 at the top of that chain, response on 2nd of February confirmed there's no objection to share the details of the current transactions with MBE. What we certainly don't have there is some protestation from the defendant to say, well, hang on a minute, you haven't done anything here, you haven't arranged these transactions. It's simply permission to share the information. And of course, that has to be viewed in the context of the other work that the claimant was performing in order to make these transactions work. So what we say is that the defendant's position on this is something which has been largely contrived as an after-the-event excuse for not paying. As to the amounts claimed, the second transaction confirmation your lordship can find at C128. And I don't necessarily need to take you to it. It's for your note. Perhaps the easiest way to view this is to simply look at the claimant's fee calculation again, which is at C93.
Yeah.
So these are 12-month T-bills for a little over 161 million Egyptian pounds. And we see that the 1.5% when converted to a dollar value is 154,719 and 22 cents.
So just help me on this. The number item 2 of that is the first transaction. Is that right?
Yes.
Which is the initially unleveraged purchase on the 9th of December.
Yes, but this is the calculation that takes place once the leverage component has been obtained.
Yes, I see that. But that was, I thought, liquidated by agreement because it was transferred to the defender's own name in January, 28th of January. And then the second transaction, which is number 1, well, 4th of February rather than 27th of January. It doesn't matter, but it's the same. It's the same Egyptian pounds, isn't it?
No, so they're different amounts. So once the transfer of the 33 million unleveraged investment is made to his personal account, there's then 1.5 times leverage obtained on that, and those sums are separate from the remainder of the transaction. So it's not encompassed by the same thing. And I may be able to dig out a couple of documents which might.
Isn't there a bit of overlap though between the two transactions?
No.
So that the first transaction, i.e. number 2 on the thing, didn't in fact last for 6 months because as part of your arrangement, it was brought back into the defender's own name and repurchased as part of the second transaction.
No, it's not as part of the second transaction. They have different dates. So the transfer is made from Global to Mr. Omran's personal capacity, and then the leverage on that is obtained at a different time to the date of investment on the second transaction. So they are distinct sums.
Right. So there was an additional purchase of T-bills in February.
Yes.
Right. Okay.
As I say, I won't take your lordship to it, but in effectively a sentence, when it comes to the no set-off provision, what we say is that the counterclaim does not need to muddy the waters of this case.
I understand that point. I don't think we need cut into the other side's time.
Certainly.
And your opponent may want to go into that in more detail, but I understand your point on that.
Certainly. Unless I can be of further assistance, those are my submissions.
Thank you very much.
My lord, good.
Yes, first. Yeah.
Do
you want to go straight on, or do you want a 5-minute break to get your papers together?
My lord, I'm very happy to proceed as long as that's convenient for your lordship.
Right. Yep. Okay.
I will try to, given timing, I'll try and rattle through the points, but please do interrupt me if your lordship has questions. Yep. Your lordship will have seen from my skeleton argument that so far as Mr. Omran is concerned, the claimant has obviously sought to present this dispute as a very simple non-payment of fees for services, which we say belies the legal and factual disputes in the case. And in particular, as is becoming increasingly clear even from this hearing, there's a real dispute over what services have been provided and whether those services entitle NBE to a fee. We say that NBE was required to arrange leverage investments and that it failed to do so. The claimants now seem to say, although as I will show your lordship, it's a development from their pleaded case, the claimants now seem to say that it can provide some sort of nebulous arranging or advisory services that fall short of actually procuring and arrange a leveraged investment, but that somehow, nevertheless, they're entitled to a fee that represents the full 1.5% of a leveraged investment. We say that's wrong, and that it's clearly wrong. But of course, I don't have to show you that it's clearly wrong. There's nothing between my learned friend and I on the legal test, and I'm sure your lordship's familiar, but I emphasise that the threshold for my client is not a high one. I do not have to show you that I am more likely to succeed at trial, but simply that there is a real as opposed to a fanciful defence. Your Lordship is not required to engage in a mini-trial, and where there are conflicts of fact, we say that Mr. Omran has provided first-hand evidence and contemporaneous documents to support his account, but that if your Lordship is unclear or considers that there's a factual dispute, then that tends to suggest that this is not a case that is appropriate for immediate judgment. We say that clearly this is a case where there is a real rather than a fanciful degree of success on the defence. So I think, my Lord, there are two main ambits of dispute that I will try and address your Lordship on. The first is the legal case that the claimant's now presenting and its definitions of what constitutes arranging services, as distinct, it appears, from execution. I do emphasise that that is a case that it has been taken for the first time in the skeleton argument. It's not the claimant's pleaded case. And I would say that I do emphasise that at the outset, because this is, of course, an immediate judgment application, and we have to show that we have a real prospect of defending the claim as pleaded, not the claim that develops in substance.
So bear with me. What is the case you say has not been pleaded?
My Lord, I will take you through the pleadings very briefly, but in essence, I say that the claimant has not based its case on saying that it provided some services that fell short of actually arranging leveraged transactions. Its pleaded case was very clearly that it arranged these transactions. Your Lordship has had something of a dialogue with my learned friend about the definition of what counts as arranging and what counts as execution. And in particular, the terms clause 7 of the terms and conditions, which my learned friend has taken you to. I do emphasise that that is not pleaded in. It's not part. It doesn't form part of the particulars of claim. It's not even pleaded in reply. And yet now the case that's being advanced is that clause 7 somehow provides the key to explaining what NBE was obliged to do. We can look at that in due course. The second point that I want to emphasise from the outset is that I think between my learned friend and I is when relevant events took place. So I will try and provide some clarity on that. But insofar as there is a factual dispute, then I say that rather supports my client's position that this case ought to advance to trial and isn't appropriate to be dealt with summarily. Just by way of, hopefully this might, learned friend, just wanted to sort of say.
So can I just interrupt you? You're breaking up a bit, and I don't know whether you'll move away from your microphone. But
I apologise, my Lord. Is that clearer?
It's clearer when it's clear. But suddenly you go silent for half a second or so every now and again.
My Lord, I will do my best, and I can try and speak more slowly. I'm just conscious of the time. Please do interrupt me if you can't hear me. I was just going to give a broad overview of the chronology. It is set out in my skeleton argument, but just to emphasise a few points. Your Lordship was taken to the carry trade presentation document. That, as I think we established, predates my client entering into the client agreement. But it appears to be common ground between us. For a number of meetings before the relationship was entered into, made clear that he was interested in investing in leveraged transactions, and a number of options were presented to him. He then enters into the client agreement and opens an account on the 18th of November, and then subsequently there is a refining of the mandate. So your Lordship's been taken to the mandate at page C42. That document was executed on, as I understand it, the 28th of November, and I think that's admitted by the claimants in reply. And we say that is a crucial document because that really is, so far as Mr. Omran is concerned, the start and end point of NBE's obligation. Now, your lordship's obviously been taken to that, but just so that we're entirely clear, the mandate is very clearly expressed as investing in Egyptian treasury bills and arranging leverage on them. It's both, and that the fee arrangements are 1.5% of the annual fees on the notional value. And in brackets, what is notional value? It's the invested value plus the leveraged value. So it's clearly, the fee structure is clearly linked to having achieved, if I might put it that way, the investment at clause 5.3. And then, of course, there are the standard terms and conditions. Your lordship's been taken to clause 7A by my learned friend, which establishes that that NBE can act via an intermediary. Now, as I've said, that isn't their pleaded case. It's not said that NBE was an intermediary for Global or AAIB, or that Global or AAIB were responsible for in any contractual sense. I won't take your lordship to it by reasons of time, but that the reference to that is A2. Paragraph 5 of the particulars of claim sets out the terms of the contract that are relied on. The plea at paragraph 6 of the particulars of claim is simply that on the defendant's instructions, the claimant arranged for the purchase of T-bills. So it's not said that this is done via an intermediary or that it would have no responsibility for execution. And then the plea at paragraph 7, which relates to the second transaction, that does not even allege that the claimant did any arranging. The plea is that the defendant, i.e. Mr. Omran, purchased the T-bills. And so it was pointed out in the defence that there was not even allegation there that the claimant arranged the T-bills, and that's responded to in reply, and I'll come to the second transaction in due course. But apart from a brief exchange in the pleadings about clause 26 of the standard terms and conditions, which for your lordship's note is on page C38, that deals with delegation, and it was pleaded by the defendant that NB may delegate any of its functions under the client agreement, but, just reading down that paragraph, our liability to you for all matters shall be as set out in clause 23 of the terms of business. So in other words, it may delegate its function, but the contractually liable party is NBE. Now, it's now said that clause 7 plays some sort of role in this, and fine, that's not pleaded, but fine, we can deal with what's been said. Clause 7 is a standard boilerplate clause. It says that the services offered by NBE may include, may, not will or must. And then there are the various parts of clause 7 that your lordship has been taken to. It says on the terms set out in the agreement. And so in other words, services that are listed, the generic services that are listed in clause 7, which it's my understanding mirror the relevant provisions of the DFSA rulebook, the regulatory framework. Those services will be provided on the terms set out in the client agreement, and it's my submission that as a matter of construction, as well as a matter of common sense, those generic services, the advising and arranging, have to be by reference to the mandate, i.e. what was NBE required to advise or arrange? It was investing in T-bills and arranging leverage on them as per clause 5.3 of the client agreement. And we do reject this case that is being advanced that somehow what's been agreed is that NBE can provide vague services that might be advice or might be arranging something that falls short of advising and arranging on a leveraged treasury bill investment. That now appears to be the parameters of the legal case between us. We say that we have much the better of that argument as a matter of common sense and contractual interpretation, but I only have to satisfy you that that is at least arguable, that it is a real and not fanciful interpretation of the contract. And I say that we obviously satisfy that hurdle. I would finally point out, by way of example, Clause 7 says, for example, that NBE will not accept deposits or it will not provide credit. As I say, these are standard terms and conditions. NBE did in fact accept deposits in this case. One can see an example of that at page C122. I don't need to take your lordship to it in the interest of time, but it's an entry from Mr. Omran's bank account where he deposits his funds. So there's clearly, we say, a difference between standard terms and conditions and the bespoke agreement between the parties on the facts of the case. And we say that the best indication of the bespoke agreement is, of course, the mandate. Your lordship has raised the point about what does arranging mean. Does it mean taking steps to procure, or does it mean that one is obliged to effectively achieve the end result? And we would say the latter, that it's distinct from execution. I don't think there's anything between my learned friend and I on that. Obviously, certain financial instruments can only be executed by certain third parties, or held in the custody of certain third parties, and Treasury bills is probably a prime example. But we say that NBE was required to do everything necessary to procure that execution took place. And we say that's important because Mr. Omran has no separate contract with any of these other entities. There's no contract with Global for Global to provide its services. There's no contract with AIB for what AIB is obliged to do. The party that Mr. Omran contracted with is NBE, and NBE's obligation is to arrange everything that has to happen by Global and by AIB. Now, on the facts, as your lordship will have gathered, it's common ground that Global didn't arrange the funds that were required to unlock the facility that NBE had negotiated with AIB. It's probably worth looking in slightly more detail at the chronology. Excuse me. The mandate was signed on the 28th of November. That Omran transferred funds into and then instructed the transaction.
Sorry, you broke up a bit then. Mandate 28th November. Then you were saying.
My lord, I apologise. Mr. Omran provided his instruction to carry out the transaction. There was then a period of delay, as is common ground, and that Global failed to procure the necessary funds. Now, and the claimant accepts that, but the claimant's position seems to be that the delay was somehow out of its control, or that it's sort of nothing to do with Global, or the fact that Global didn't procure the credit for the funds that were necessary to unlock the credit facility is somehow nothing to do with it. And we say that that's wrong as a matter of the contract. That doesn't exempt NBE because its obligation was to arrange the transaction, and it was responsible for the mandate, which was to arrange the leverage investment. And I'd just take your lordship to page C44. This is the document that's relied on in the process. I think your lordship was taken to show that that Mr. was and AIB was somehow involved. I would just point out to your lordship that this describes the process by which the leveraged investment is going to take place. It is, of course, headed. It's a document headed with NBE's, DIFC's letterhead. And it's made clear in bullet point 4, for example, NBE will transfer the amount to Global. Global then instructs AIB to transfer the amount. NBE will provide instructions to AAIB to buy the T-bills. And that's because, of course, the T-bills are going to be held in Global's account rather than in Mr. Omran's personal name. And then NBE charges subscription fees of 1.5% per annum for leveraged transactions. I think your lordship was taken to that earlier. Yeah. And we say two things about that. Firstly, that this document makes clear that responsibility for the execution process is squarely with NBE as the co-contracting party. And secondly, that as a matter of construction, the subscription fee of 1% is clearly linked to a leveraged transaction, and that we say is entirely consistent with clause 5.4 of the mandate. And so we say, in terms of the contractual construction, my lord, there is at least a real prospect of success in arguing that the terms of the contract required NBE to arrange the leverage. It may not have had responsibility for the final execution. Clearly, AAIB was providing the credit and Global was holding the funds. But the contracting party that was responsible for putting all of those pieces together was NBE. We say that's the common sense meaning of the contract and an argument that has at least real prospects of success. Then, my lord, we come to...
Can I interrupt for a second?
Of course.
I understand you say that the claimants were required to arrange the leverage, but is there a time constraint on that? And to what extent does the leverage have to be put in place at about the same time as the purchase of the T-bills?
Oh, my lord, we say yes, there is a time constraint. Perhaps if I take your lordship back to the defence, that's at page A6, beginning on A6. If your lordship turns to page A7, paragraph 3.3, this is in the pre-meetings before the account is opened. We say that NBE advised Mr. Omran that leverage could be arranged within 1 week of depositing funds in his account. If one looks at over on page A8, paragraph 5.2, we've pleaded clause 6.3 of the contract, but it's probably easier to just look at it here. Actually, under the terms of the contract, NBE is obliged to try and act on instructions received on a business day on the same day, but that it might be the next day, depending on timing. So actually, the time frame of 1 week, we say, is already an extension from the contractual terms. Again, over the page, on page A9.
Mm-hmm.
We say that time was of the essence, paragraph 7, my lord. We say that time was of the essence of making the investment because, as had been discussed between the parties in their meetings, although this was a lucrative trade, and in particular the leveraged element of the trade provided an uplift in yield, both the Forex in Egyptian pounds was reducing yield on the unleveraged T-bills. So it was imperative that these trades were entered into as quickly as possible. And we say that everybody was well aware of that, but in any event, the contract required NBE to act expeditiously in carrying out instructions. And so my lord, I'm sorry, my lord.
Just to be clear on this, is it your case, looking at the mandate, that investing in treasury bills and arranging leverage on them were to be done simultaneously or as near thereto as possible?
It is, my lord, precisely. It's envisaged as one and the same transaction. It's not to be done piecemeal over a 2.5 month period, which is in fact what happens. And my lord, that brings me on to a point that's been made by my learned friend about the express instructions that were given. So Mr. Omran instructed NBE to carry out that transaction on the same day that he deposited funds into his account. As set out in paragraph 8, it was on the 8th of December sorry, on the 6th of December, I believe, my learned friend took you to a document saying, yes, please, please purchase the T-bills. Now, firstly, that was already a delay of over a week since providing the instructions. And secondly, as my learned friend's already told you, there was no leverage arranged at that time. NBE proceeded to purchase the T-bills. Now, my learned friend seeks to rely on this and say that they couldn't do otherwise than act on the express instructions of Mr. Omran, and his instructions were simply to purchase unleveraged T-bills. We say that's not quite right. If one looks at Mr. Omran's witness statement, that's at page B19. Sorry, my lord, I'm scrolling very slowly.
That's right, I've downloaded this.
So on page B19 at paragraphs 16 and 17, Mr. Omran describes giving his instructions. And you can see here there's already a delay, and he continued to chase NBE for updates as to when the leverage would be arranged. At paragraph 17, even though NBE advised me on the 5th of December to purchase unleveraged T-bills, this was on the express understanding and instruction that NBE would forthwith arrange the leverage on those T-bills, which it subsequently failed to do. At no time did I give instructions to NBE to simply purchase unleveraged T-bills.
What paragraph?
That's paragraph 17, my lord, on page B.
Yeah, got it. Yeah.
And so we say NBE cannot simply rely on the fact that there was a press go on purchasing the unleveraged T-bills, that at all times and throughout this transaction, consistently, it was contemplated that it would have to arrange the leverage. And my learned friend said, well, we had to act on those instructions, otherwise there could be a claim for breach of mandate. Well, my lord, that's precisely the claim that has been brought in by way of the counterclaim, because of course the delay in arranging the leverage has exposed Mr. Omran to loss, and he says that at this point NBE is in breach. It hasn't complied with the mandate. It's invested Mr. Omran's money in T-bills, but it's failed to arrange the leverage. It's failed to execute his instructions timelessly, and what happens thereafter? We're at the 5th of December now. What happens thereafter is a series of effectively damage mitigation, trying to arrange the leverage, trying to access the facility. And we can see that Mr. Omran continued to expect that the leverage would be arranged in accordance with his instructions. That's clear from the contemporaneous documents. By way of example, page C55. This is an email from Yahya Omran, which is Mr. Omran's son. Please note that we do have some queries as follows. The email's in black, and then I think the response is in blue. Again, point 5. Kindly update us regarding the date the leverage will be done. We will update you soon on the exact date. And then again, a few pages later, C59. You've already been taken to this document. We will settle the invoice after the leverage process is complete. So it's clear that at this point, which is 25th of December 2019, the leverage still hasn't been arranged, where that's about a month in from the initial instruction. And Mr. Omran is regularly chasing to find out what's being done. And there's a further example on page C62 of that, but we don't need to take your lordship there. So he's continuing to chase the leveraged portion, and NBE have sought to somehow divorce this from the initial instruction to buy the T-bills. But we say they're clearly intended to be part of the same transaction, and that's the transaction that's agreed in the mandate, clause 5.3, investing in T-bills and arranging leverage on them. And that's what Mr. Omran at all times instructed NBE to pursue. So we do dispute.
Sorry, you stop. I heard we do dispute, and then you went silent.
My apologies, my lord. Can you hear me now?
Yes, I can, thank you.
We do dispute that they executed Mr. Omran's instructions, and that, my lord, is the counterclaim. It's a claim losses that are occasioned in executing. And we can come back to it, but in short form, my submission in response to my learned friend is, from what I've told you, it's very clear that the factual elements of that counterclaim and the legal elements are inextricably linked with the claim. It all depends on what we say the services were that NBE was obliged to perform, and whether it performed those services. They are one and the same thing, and we say that there would be real prejudice to the defendant in the pursuit of his counterclaim if immediate judgment was somehow entered on the claim.
Can you? I understand how you put it on the counterclaim. There's delay in arranging leverage, but do you go further and say that no sum was due at all, regardless of counterclaim, because there was no leverage transaction?
My lord, we do, and I'll somewhat factually actions are related, but we the counterclaim. This is not a case where the counterclaim is effectively the only defence by way of set-off. We say that there is a real substantial defence, even disregarding the counterclaim.
Yeah. I mean, sorry to interrupt you. I know you're conscious of time. I'm just interested in this. The counterclaim would be answered, arguably at least, by the no set-off provision. So put that to one side for the moment. In terms of whether or not this is a leverage transaction on which they're entitled to claim their fee, I mean, I think the way it's put, if it had to be a leverage transaction, would be that although it started off as unleveraged, by February, I think it is, leverage was obtained, and then it became a leverage transaction. Is that how you understand the argument?
My lord, yes, and what we would say to that is leverage was arranged, but not by NBE, and so I'll take your lordship through that, but we do dispute that they arranged the leverage in the relevant sense under the contract. So just pausing there, I just emphasise that NBE's case, as it's now articulated, is that the fee is due in respect of advisory or arranging services that might fall short of actually procuring the result, i.e. the leverage transaction. And we say that that's not right. And we say that on the facts, well, there is at the very least an arguable case that NBE didn't perform those services and that it is not entitled to the fee that it claims of 1.5% on the leverage transaction. Now, I think my learned friend suggested that it was my case that if NBE didn't in fact arrange the leverage itself, then it wouldn't be entitled to any fee for anything that it did. I don't necessarily go that far, but of course the fee that is claimed and the fee that is the subject of this application is 1.5% of a leverage transaction. And we say that it doesn't get that if it didn't arrange the leverage. And so it's now, there are two parts to that, my lord. Firstly, there's I'll come to in due course. Just pausing there, as regards, we say that in any event, there was an agreement between NBE and Mr. Omran that Mr. Omran would effectively be held harmless from the delays in executing the leverage, and that there was an agreement that NBE would bear the loss that was caused by the delay in arranging the leverage. Now, it's said that there's absolutely no evidence for that. We do dispute that. We say that there is reference to it in the contemporaneous documents. My lord, you were taken to page C59, an email that records, "We shall settle the invoice after the leverage process is completed," and reading down, "As per our last meeting with Mr. Hussein," that's Mr. Tantawi in the pleadings, "the delay in completion of the leverage process shall be settled by NBE." So at a meeting with Mr. Hussein, it was agreed that the delay shall be settled. Mr. Omran's very clear in his defence that what that means as far as he's concerned is that NBE will compensate him for the delay. There's further support for that, my lord, at page C129. And again, I apologise, my scrolling is slightly slow. So at page C129, this is an email of February the 22nd, 2020. And just looking at the end of the second line of that, since as per our meeting and repeated promises, NBE stated that they shall bear the losses incurred by us due to the delay in arranging the leverage for almost 2.5 months. And so again, we say there's contemporaneous evidence that there has been a meeting and that there have been repeated promises by NBE that it will bear the losses. Now, the claimants point to a lack of evidence, but we say it's notable that the claimants themselves have not actually provided any evidence. The witness statement that's been given in support of this application is a witness statement by one of the claimant's legal team. It's a solicitor witness statement by someone that has no first-hand knowledge of the facts. And we say that not only is that contrary to Practice Direction 1 of 2016, but it's actually extremely unhelpful because it's clear that Mr. Tantawi's evidence is obviously going to be relevant to this question as to whether there was an agreement between NBE and between Mr. Omran as to bearing the losses caused by the delay. Mr. Omran's provided his witness statement. There's no witness statement from Mr. Tantawi. And I emphasise that, my lord, because of course under the Rules of Court 24.2, your lordship has to take into account not just the evidence that we have available today, but also what evidence could or would be available at trial. And we say that we would want to hear from Mr. Tantawi about what he says about this. We're clear that NBE promised to compensate Mr. Omran for the delay. That's denied by the claimants, but they've not put forward any witness evidence to contradict Mr. Omran's account. And so we say that's a clear factual dispute and a clear area where the court would benefit from witness evidence and cross-examination in the usual way. And of course, if that's right, and if there was an agreement that NBE would bear the losses, then there's a real question as to what those losses are, how they're calculated. They're obviously sued for in the counterclaim, and how they quantify as against the fee. So we say again, that is a defence with a real prospect of success. Your lordship can see that there's at least some documentary evidence supporting that, and that we would expect to have witness evidence in due course about what went on. So that's defence number one, I say, to the first transaction. But coming back to your lordship's point, in any event, we say that the leveraged element of the transaction was not arranged by NBE, and so it's not entitled to the fee. And here's where I think there's some confusion as to precisely what went on and how the first transaction relates to the second transaction. So I will try and break it down. It's clear from Mr. Omran's witness evidence that obviously there's this ongoing delay. We get to December, the end of December 2019, and there's no leverage. We get to early January and there's still no leverage been arranged. And there's ongoing discussions between NBE and Mr. Omran. And ultimately, it's agreed that NBE will introduce Mr. Omran to AAIB, and they will see whether it's possible for Mr. Omran to deal directly with them to arrange the leverage. Now, it's been said by my learned friend that NBE arranged that credit facility with AAIB and that he would be able to access the same facility on the same terms. That isn't in fact the case. That's not what happened. Mr. Omran was not allowed to access the credit facility that negotiated for at the meeting. advised by AAIB that they would be willing to enter into an agreement with him, but that he would have to invest significant further funds of his own account in order to make any facility available to him. My Lord, I think you were taken to C61. Just want to clarify here. At the top of the page, this is an email from Mr. Omran, which we say is clear. We're waiting for the update regarding the leverage within 48 hours from our meeting, and then skipping down to paragraph 4. If the leverage issue for those T-bills, that's the first transaction, is not resolved yet, then we shall proceed with selling the T-bills as soon as possible, transferring the money to our personal in order to obtain the leverage. And we say directly means what it means. Mr. Omran is instructing NBE to go and do this for him and to enter into negotiations on his behalf. He's going directly to AAIB. Now it's said, but I think it was said to you that the email below in that transaction, which refers to an additional AED 25 million, I think it was said that that was a reference to the additional amount that AAIB advised would be necessary. Just to be clear that that's not the case. This is an email sent on the 6th of January, which is well before the meeting with AAIB. And I think it's worth just turning to paragraph 30 of Mr. Omran's witness statement, which is at page B22. Oh, I apologise. Mr. Omran explains that that email is in fact nothing to do with AAIB. It refers to an additional amount of 25 dirhams, which was money that NBE requested as part of us assisting them to raise the 40 million, which, if your lordship recalls, is the amount that Global was supposed to raise but failed to raise, in order to try and unlock the original AAIB. So there's a request by NBE to see if Mr. Omran can invest. But that ultimately doesn't come to fruition. And Mr. Omran's clear that that's nothing to do with AAIB's additional deposit, which AAIB told me about when I first met with them on the 22nd of January. So just to clear that up. Then, as my learned friend said, on the 22nd of January, he opens a client account with AAIB, and thereafter he deals with AAIB directly. What happens is that AAIB and Mr. Omran negotiate the terms of a credit facility. It's not the same facility that it had originally offered to Global. It's a facility that was made available to him after the investing of significant further funds and on different terms. So, for example, one sees at page C100, I think that's right. This is an email chain that we sort of have to read up and backwards. This is an email to Mr. Omran from Ola Madkour, the relationship manager at AAIB. I just note that there's nobody in that email chain. NBE is not copied into this. Please note the rate for the additional T-bills.
What date is this?
This is, it's the 30th of January, my lord. Sorry, that date appears on the previous page, on page C. Week after the meeting. Purchase of T-bills. We're also in the process of selling the treasury bills from Global to your account. Once done, we will confirm this too. That, my lord, is, so just to be clear, the first paragraph is the second transaction, which is the additional investment that Mr. Omran is going to enter into directly with AAIB. But in order to meet the threshold value to get the credit to leverage the investments, he also needs to put in the original T-bills. And so that's the second paragraph saying, we're in the process of selling the T-bills from Global to your account. And I think your lordship was taken to a document that was a purchase order, and I think there was some confusion about why that would be a purchase order. My understanding is that because the T-bills were held in Global's name when they were originally purchased, the way to transfer those across was to do a buy order and a sell order. So that's why the document that you were taken to looks like a purchase of the original T-bills. And then it's said by NBE that, well, we helped because we transferred your T-bills across to AIB, and that somehow counts as arranging. And we say, well, that's not arranging the leverage transaction. Manifestly, NBE had to cooperate in transferring the T-bills across. They were the only people who could instruct Global to sell the T-bills and procure that then Mr. Omran purchased them in the name of his account with AIB. But they didn't arrange any transaction. They simply passed the T-bills across as he was instructed to do. And then it's clear that thereafter, AIB is the entity that's doing the arranging. It purchased the T-bills for the second transaction. We can see on page C99 and C98 there's a negotiation of the rate that will apply for those second transaction. And then at page C95, my lord, this is the exhibit to Mr. Omran's witness statement. This is his agreement with AIB, which makes clear that this is the facility amount for the credit for the leverage, and this provides for AIB to charge fees in relation to those services. And so really the high point of what's said on NBE's behalf is that there was a meeting with AIB at which it became clear that the facility NBE had originally negotiated was not going to be available. Mr. Omran then negotiates a facility directly. NBE helped to transfer the T-bills across, and thereafter it had absolutely no role. AIB provided the credit, AIB purchased the second set of T-bills, and AIB arranged the leverage, not just on the second transaction, but the first transaction. And the high point of NBE's case seems to be that it's copied in on some emails, which my learned friend says is evidence that it must have been providing some services. Well, we say quite the opposite. If it was really providing the services, it wouldn't need to be informed. One can see at page C83.
C83.
C83, my lord. This is an email between NBE and AIB. One infers that they've asked to be kept informed. At the bottom of the page, AIB say, once Mr. Omran sends us confirmation from his end, we can send copying NBE. We haven't yet got an email from their end allowing us to do the same. And then at the top of the page, confirmed there's no objection to share the details of the transactions with NBE. Well, my lord, we say that's the absolute highest that it can be put, that the details of what AIB was doing was shared with NBE. And in my submission, that's consistent with the fact that there's been an ongoing delay, and on my case, that there's an agreement to waive the fee, an agreement to compensate the loss that's been caused by the delay. It's entirely consistent with what's happened, that NBE would want to be kept informed, but it doesn't follow that what it has done is arranged a leveraged transaction. It didn't. It failed to arrange the leveraged transaction, and as a result of its failure, Mr. Omran had to deal directly with AIB. And we say that's consistent with the documents. But if one really wanted clarity, then again, my lord, I come back to the same point. One would expect at trial to have evidence from AIB as to what it was doing, and evidence from NBE as to, at least in respect of what happened at that January meeting. And we don't. We have an account who is very clear that he dealt with AAIB directly, and we don't have any factual evidence from anybody else that was actually on the ground, so to speak. We simply have assertion via a solicitor witness statement. And so, my lord, we say that you cannot be confident that there wouldn't be better evidence available at trial to see what was in fact going on. But at least in my submission, there is a real prospect of success for Mr. Omran showing that NBE did not arrange the leverage within what we say is the relevant meaning of the contract. That obviously has two arms. There's the construction of the contract that I've taken your lordship through, and then there's the factual element as to what NBE actually did, both with regards to the first transaction and the failed leverage, and then the second transaction, which we say is entirely divorced from NBE, where Mr. Omran simply instructed AAIB directly with his own funds, new funds that hadn't come from any account with Global, to purchase another chunk of T-bills and to leverage them. And we say that in regards to the second transaction, there's really no argument at all that NBE arranged that leveraged transaction. The factual dispute in a nutshell. Apologies, I just come back to the. It's been said that because the loss is particularised at £36,000, dollars, I beg your pardon, that somehow shows that it's a lawyer's construct. We do dispute that. Mr. Omran has taken steps to calculate his loss. Obviously, we're at a very early. It may be that a course to particularise the exact on any view quite complicated transactions across several currencies. I do just note that the claimant hasn't asked the defendant for any further particulars or to provide a breakdown of those losses, or said that it doesn't understand them. But more fundamentally, my lord, as I've already indicated, this isn't the sort of case that's referred to in the authorities referred to by my learned friend in his skeleton argument. I don't dispute the test set out in those authorities, but those were all cases where there was a claim for fees, and then the counterclaim was effectively the only defence. In other words, it was accepted that under the terms of the agreement, the fees were due, but there was also a claim that was said to set it off. And we say we're not in that scenario. There is a dispute as to whether the fees are proper, and the legal issues that are effectively common between the. And so it's not possible, we say, to sever off the counterclaim without doing real prejudice to the defendant. Because, of course, if my lord makes a finding, for example, as to the scope of services to be provided or a construction of the contract, then that binds in respect of the counterclaim, or at least potentially binds. And so the defendant is shut out of properly pursuing his counterclaim. And we say that that's a compelling reason why the claim should go to trial and that it should be dealt with in the round. My lord, I'm conscious that I've somewhat rattled through that in the interest of time, but I'm very happy to assist your lordship further if I can on any of those matters.
No, I have your points, I think. And in short, on the main point, would it be oversimplistic to characterize it in this way, that in terms of the mandate, you say the claimant was required to invest in treasury bills and arrange leverage, all as part of one transaction. In other words, it was to take all steps necessary to procure that you had a leveraged investment in treasury bills. It took steps via Global to try to arrange leverage. Those steps came to nothing in the end, for whatever reason. and the rest was, if you like, damage limitation. After that, you say your client took back in his own hands the arrangement of leverage, both in respect of the existing purchase of T-bills and the future purchase of T-bills, and that had nothing apart from the administrative input necessary for the transfer of the existing investment and the introduction to AAIB. That had the services provided by the claimant were not the services covered by the mandate.
My Lord, that is exactly it, and my Lord has put it much more succinctly than I have. But yes, that is our case in a nutshell.
Right, thank you very much. Well, unless there's anything else you want to add at this stage, I'll see whether Mr. Doherty wants to come back on anything. I think you can come back on anything which has taken you by surprise, Mr. Doherty. Are you there?
Yes.
Yes, you
are. Yes, Lord. Just a couple of points I'll try and deal with as briefly as possible. One of the suggestions was that under the terms of the client agreement, MBE's obligation is to arrange everything that has to happen.
Yeah.
I have to say, not entirely clear what would be meant by that. The contract says what it says. It's not clear how far my learned friend goes with that submissions. We know that MBE can't execute the deal, and we know that it can't provide credit. And it was always known that that would be through an intermediary. On that analysis, what my learned friend seems to be suggesting is effectively one has to hang over AAIB's shoulders, looking at their computer screen until they click the button executing, which is clearly not what is envisaged by the scope of services. It's a question of how far one has to lead the horse to water.
I think, to be fair, what is suggested is must take all necessary steps to procure that leverage is obtained from whoever.
Yes, and the way that it's being put in my learned friend's submissions is, well, we would say this. What they're saying is that the highest the claimant can put its case is that it was involved in some emails, but we've already been through what is and what is not disputed in the pleadings, and it's not disputed that the advice was provided extensively about the transactions. It's not disputed that Mr. Omran instructed MBE to arrange the transaction in his personal capacity with AAIB. It's not disputed that the credit facility was arranged and negotiated with AAIB. Mr. Omran is not suggesting anywhere that he negotiated that facility himself. It's not disputed that the introduction was made by MBE.
So I think that is the defendant's case, respondent's case.
Sorry, which aspect?
That he negotiated the deal with AAIB himself after the failure of the global attempt at leverage.
Yeah, I think what he says is, I did it myself, and in that context provides evidence about the January 22nd meeting in which he is taken to AAIB by the claimant, which again, as I say, is accepted on his pleaded case. It's not disputed that MB was involved in ensuring that his investments with Global were transferred. Effectively, what I would suggest my learned friend's submissions boil down to is that because it wasn't involved in the final email sending the execution instruction to AAIB, that it's entitled to nothing, despite the extensive services provided up to that point. And we say that that's not a reasonable interpretation of the contract, and not one that has real prospect of succeeding. And Your Honour, or Your Lordship, is entitled to ask in that context, if one were to remove MBE from the equation in January, would this leveraged investment have happened? And the answer, we say, quite clearly is no. And built into that is that there's clearly a distinction, which in my submission, Mr. Omran has not appreciated, between obtaining the investments in one's personal capacity and the idea of doing it himself. There is no dispute that the investments that were arranged in January and February 2020 were in his personal capacity in an account set up by AAIB at the meeting on the 22nd of January in his personal capacity. But that's very much different from arranging to do it himself. My learned friend submitted that, and I've tried to quote her as directly as I can here, AAIB is the party doing the arranging, they purchase the T-bills. And my learned friend then referred to the facility agreement with AAIB. But that strikes precisely at the point that the defendant has got wrong about this case. MBE was never going to purchase the T-bills. They didn't purchase the unleveraged T-bills for that matter either. AAIB did. But that's exactly what the execution document for the investments spelled out from the beginning, which is that execution services will be provided by AAIB. The credit facility will be provided by AAIB. And so, of course, there is no credit arrangement with MBE in those circumstances. As I say, it's MBE is leading the horse to water. It can't force it to take a drink. I think as a final point on that issue, if this is simply a question of what turns on arranging under the scope of the client agreement, that's one of the issues which we say the court is perfectly positioned to, I think the expression in easier was grasp the nettle on. It's a question of law. It's a matter of interpreting the contract, and Mr. Omran or anyone else's evidence isn't going to have much to say about that. Bear with me, let me just check if there was anything else to add at this stage. Yes, the final point I want to address your lordship on was the idea that time is of the essence being a central part of this case. The first thing we'd say about that is that it directly contradicts the express instructions given by Mr. Omran in December 2019 and again in January 2020, which was to proceed with the first and second transactions. So he was obviously still engaged at that time. And what I'd suggest is if time was of the essence, what he would have said then is, forget it, I'm not investing in this. But even at its highest, if one takes that as being correct and time was of the essence, it might be relevant to the counterclaim, but it's not relevant to the question of whether Mr. Omran is obliged to pay for the services that he subsequently instructed after the global deal ran into problems. So if there is a claim for damages for delay in the global investment, it is still a matter of fact that instructions were given to proceed with transactions in some form, whether it was damage limitation or not, and advising and arranging services were provided for both of those transactions, and fees were therefore incurred for both of those transactions. It may well be that Mr. Omran has a perfectly good claim arising from the delay and that he has suffered a loss as a consequence of that, but that is an issue to be dealt with on the counterclaim. It's not relevant, we say, to the termination of the claimant's claim, which is effectively were arranging services provided and is a fee incurred on that basis. And we say it is really as simple as that.
Yes, thank you very much.
Thank you.
Well, in the course of argument, I'm very grateful to both counsel for their submissions and for their helpful skeleton arguments beforehand. But I've come to a clear view in this matter. I don't think anything would be gained by reserving judgment and giving judgment later. It seems to me that I should refuse the present application for immediate judgment. In those circumstances where there will then be a trial, it's inappropriate for me to give detailed reasons, but in outline, my reasons are these. The test is well established, both in terms of Rule 24.1 of the rules of the Dubai Court. The court may give immediate judgment against a defendant on the whole of a claim if it considers that the defendant has no real prospect of successfully defending the claim or issue, and that there is no other compelling reason why the case or issue should be disposed of at trial. And the test for that was set out by Justice Giles in GFH Capital Limited against David Lawrence Haig, to which I won't quote in full, but the question is whether the defendant has a realistic as opposed to a fanciful prospect of success. And I take into account that not everything said in a witness statement need be taken at face value. On the other hand, the court is not here to try at this stage disputed facts which may be vain unless one side or the other is clearly wrong on the documents. It seems to me that there is an arguable case, and I say arguable, I don't say whether it is going to succeed or not, but an arguable case raised by the defendant that the mandate to which the parties subscribed on the 28th of November 2019 required the claimant to advise the defendant in investing in Egyptian treasury bills and arranging leverage on them. Arranging in that context, meaning that the claimant was required to take all steps necessary to ensure that leverage was obtained, not providing the leverage itself, but obtained from others. But in other words, the arranging was not simply a matter of introduction or advice and so on. It actually required the claimant to procure that leverage was obtained and obtained timelessly, that is to say, at about the same time as the investment in the treasury bills. As I say, I don't say whether that's right or not as a matter of construction, but it seems to me to be arguable in the sense contemplated by the authorities. And on that basis, the defendant has a fairly straightforward case, which may or may not be correct, that the claimant failed to procure leverage in accordance with the contract, to arrange leverage in accordance with the mandate, and that what happened then all flowed from that failure. And on the defendant's factual evidence, he, in a sense, and I'm using my own words, took matters in hand himself, requiring the claimant to assist where its assistance was necessary to extract global, for example, from the chain and other such matters, but that the defendant himself thereafter made arrangements with AIB, which resulted in leverage being obtained and a further leveraged investment in treasury bonds. Now, if that is right, then it seems to me that it is highly fact sensitive, and I only have evidence from one side on this at this stage. If that is right, there is at least an argument that the claimant would not be entitled to charge a fee on the leveraged transaction that eventually materialized. For that reason alone, it seems to me that there is clearly an arguable defense in the sense used, a realistically arguable defense, which ought to go to trial. I should say that although I accept the case law about the efficacy of the no set-off provision in the contract, it seems to me that there may be circumstances where the argument as to that I've described, which might sound in entitlement to fees in the first place, or equally might sound in damages to be raised by way of counterclaim, that where those arguments are so bound up with the same point, there may be a case for saying that the no set-off provision has less force. But since I don't decide the case on that point, I will say no more about that. I'll simply grant leave. I think technically I refuse the application and grant leave to defend. Is that the correct terminology? Either of you got help on that? Maite, you are here, are you?
My lord, yes. I think simply refuse the application would suffice for my purposes.
Yes.
I should also address your lordship in the circumstances of your lordship's judgment. I do ask for my client's costs of this application, and there was a schedule of costs served, which has hopefully made its way to your lordship.
I haven't seen the schedule of costs, but it may be my fault rather than. What's the total amount you're claiming?
The total, my lord, is 140,987 and 34 dirham.
Sorry, 191.
Sorry, that's 149,987.34 in dirham.
Right. And Mr. Doherty, is that schedule of, well, first of all, what you say about costs generally, and secondly, have you seen that schedule and do you have any comments on it?
I have seen the schedule. I do have comments. I don't know whether that would mean that your lordship would need the schedule in front of you. I'm conscious.
Take it one stage at a time. The first point is, do you oppose the application for costs?
I think on the question of principle, I don't think that there is necessarily reasonable grounds to do that, but we do challenge the amount that's being claimed.
Do you have a rival amount? Did you submit a schedule of costs yourself?
Yes,
what was your amount?
Claimant schedule of costs is 94, with just shy of 95,000 dirhams.
Yes, that was your schedule.
Yes.
But it seems to me that the difference is such that the better thing is to have the costs assessed, if not agreed. Do you want to say anything against that, Ms. Hurst?
My lord, not in circumstances where your lordship doesn't have the statements of costs in front of him. That seems like a sensible way to proceed. I'm grateful.
Very well. I'll award the defendant the costs of this application to be taxed, to be assessed by the registry, if not agreed. Thank you very much. Maite, is there anything else I need to deal with?
Not from me, my lord.
No, your lordship.
No. Thank you very much for your help.
Thank you.
Thank you.